Okay, good afternoon, friends. Welcome to this afternoon's lecture by Shibani Ghosh. I'll introduce her very shortly. Just a couple of sentences about this particular series of talks that we're having. What we thought we'll do in this series of lectures is try and shift the conversation on climate change in India a bit away from international negotiations, which is the main thing that gets discussed around climate change, to how climate thinking and climate action shapes life in different ways. We have been fortunate in having two speakers before the evening. The first lecture was delivered by Elizabeth Chatterjee on the emergency in India in the 1970s and what it had to do with climate shock. And the second lecture was by Sarah Carson on predicting wind and rain, the search for a Sanskrit meteorology in North India. So I'm very delighted that we have Shibani Ghosh with us this evening. She's going to be talking about climate law, which is in fact just come from the court. So very warm welcome, Shibani. And we hope as we go ahead to have people to speak on architecture, energy, health, a range of issues which now are getting tied up with issues of climate, and then to kind of hopefully ground the climate conversation into some things that are happening here. And eventually, for those of us who are in this room, those who are online, we hope to announce a postdoc position pretty soon on climate change and democracy in India. So if you know of people who are interested in applying for that position, we should be announcing it within the next fortnight or so. So it's something that we're very keen to bring scholars over for. Okay, Shibani Ghosh is currently a fellow at the Center for Policy Research in Delhi. Prior to this, she did her BA in law from the National University of Juridical Sciences in Kolkata, then a BA in civil law from Oxford, and also an MSc in environmental law and management from University of Oxford. She's also an advocate on record in the Supreme Court of India and specializes in environmental law and appears in cases before the Supreme Court and the National Green Tribunal. She has authored several articles and opinion pieces on environmental issues, and a volume, which I read with great delight. It's available outside for those who want to buy. Indian Environmental Law, Key Concepts and Principles, edited by her, and I think it's a co-edited volume, is it? Of course, it's an edited volume, came out from Orient Black Swan in 2019. And Shibani talks to us today on how climate figures in Indian law. Thank you, Shibani, for joining us, and the floor is all yours.
Thank you. Thank you so much for having me today. And apologies once again for the slight delay in the start of today's session. It's a real delight to be here. Thank you so much for inviting me and giving me this honor. Just as I know I was introduced as this is going to be about climate law, but actually it's a little bit of the law, but a little bit more on how the courts have actually engaged with the issue of climate change. So more on litigation and the prospects of litigation. And of course, one only goes into that after touching on law. So I'll definitely look at a bit of the possibilities of how law in India looks at climate. And also I'll, please feel free to stop me at any point if you need any clarifications or, have any questions. We lawyers are awful at speaking in a language. I mean, I really try not to speak in the legal language, but if there's anything you want me to repeat or explain, please do stop me. I wouldn't mind, the interventions at that stage. So if I think I have a PowerPoint presentation, and I'll start with that. So just to kind of give you a context, but it seems like you've already had two sessions on this, and I'm sure there are a lot of people in this room who are working on climate change. So perhaps my first slide, I could just go over it very quickly. It was just a context setting slide. Yeah, just go back to the one before. Yeah, just to kind of say where we are in India. We are the 7th most vulnerable country to the effects of climate change. And this is only 2019. And I'm sure we're getting more and more data that shows how vulnerable we are, given our coastline, given our demography, and also other ecological systems as they are in our country. We are, of course, the 3rd largest emitter of GHGs, not in terms of per capita, but just in absolute terms. And the Government of India report in 2020 also highlighted what kind of changes we are witnessing in India in terms of rise in average temperatures, decrease in monsoon precipitation, extreme temperatures are rising, rainfall events are rising. There's compelling scientific evidence that human activities have influenced these changes in regional climate. So just the next slide. So now the question is, what is climate litigation, and why do we think that's something that we need to talk about? It's been defined in many ways. A recent report by UNEP, it's a pretty detailed report and a very interesting one, that describes climate cases or climate claims to include cases that raise material issues of law or fact relating to climate mitigation, adaptation, or the science of climate change. And now there are other definitions as well. And I'm actually going to use the definition that's been used by Peel and Lynn in their 2019 article, which is a much broader, and it's an article which actually focused on the global South. And for that reason, it's far more relevant to India and the kind of cases that can come to the Indian courts or are coming to Indian courts. And in their article, what they highlight is that, the discussion so far when we're talking about climate cases has always been what's happening in the US courts, what's happening in Netherlands, what's happening in Australia. So the focus has very often been on the developed countries and their approach to climate change through the courts. But if you look at the global South, actually, there is litigation that's creeping in, and that's actually, and is very significant. But if we go by the traditional definition of climate litigation, it may not fall as a core case. So they push for what they call the peripheral cases or the invisible cases, which also are discussing climate change, but in a very different global South perspective, which I think is very important. And more scholars are looking at that. So what they write is, we therefore believe there's value in exploring a broader understanding of climate litigation to capture these otherwise invisible cases. In particular, we argue there's a need for concepts of climate litigation that are able to capture lower profile cases where climate change is more peripheral to the arguments in or motivation for the lawsuit. So that's kind of where that's my entry point to analyzing the kind of cases that have come to the Indian courts so far. So the definition I use to characterize climate cases is the litigation that is motivated in part or full by concerns relating to climate change, whether it's the impact or the cause, therefore greenhouse gas emitters, or both, as well as cases that refer to, or the judges refer to, the design and implementation of law and policy that relate to climate change. That may not be on climate change, but in some way there is some incidental or direct link to climate change. Now, for those of you who are interested, the Sabin Center keeps a very close track of the number of cases, and you'd be surprised. This is what I checked in the last 24 hours. So in the US alone, there are over 1,500 cases on climate change. But outside of the US, there's not even 700 cases. And this is like all of non-US cases. So the focus has always been on the United States, but slowly moving out. And I'm not going into the definition here, and that's in case people are interested, right? And the database is very user-friendly to kind of figure out what kind of cases, what arguments, which laws. We can go to the next, so again, going back to the same piece where they define core cases, peripheral cases, and incidental cases, which they exclude. Now, incidental cases, I think in India would be a bunch of the cases, right? So I don't know how many of you have to analyze Indian court judgments or have to look at them, but our court judges say a lot. And often that is not necessarily related to what we are asking them about, right? So often it's sometimes called obiter, but it's sometimes chit chat. So a lot of the judgments, if you kind of do a search and look for climate change, greenhouse gases, global warming, any of this Paris Agreement, any of these terms, lot of judgments come up. But those are often in like here are the number of environmental problems that we are faced with. So, but that's not a climate litigation case then, because what we really need to look at is where climate is actually considered either by the party or by the judge in some way or form. So there are lots of cases, all of which I have excluded in my analysis is usually excluded as well. But there are in India very few cases, and I'll come to them in just a bit, where climate change is the core. In fact, I found only 3 cases, I think, in which climate change is the core issue, and the rest, about 15, 17 of them, were peripheral. They are one of the many issues that were raised by the party or by the judges in their judgment. So it's also possible in Indian courts, not so possible in courts abroad, that the judges actually rely on an argument which the parties have not raised. It doesn't happen in many jurisdictions, but in India, just the way our cases are heard, just the way our judges write the judgments, it's possible. Again, this is something just kind of showing this graphic just to show how climate cases, again, some are at the center, but going absolutely on the outer circle. I'm sorry, I can't read it, but I just know what it is. The last concentric circle is about, fracking cases and all, where you could, isn't it? Yeah, where climate change could possibly be a motivation, but it hasn't been raised in the case. So this is kind of moving outwards to show how climate becomes less and less a central issue in the case. Okay, so when we the UNEP, how does it categorize cases? The way they come up with, and I'll give a few examples as well. One is the issue of climate rights. And this is perhaps something many of us who work in this field have come across, people raising issues of human rights violations or environmental right to clean air, leading to right to not having greenhouse gases emitted. So there are a bunch of cases which are based on a rights-based language that has been raised by the parties, saying that we have either a constitutional right or a statutory right, and a bunch of cases are around that. The second category is of domestic enforcement. Many countries by now actually do have climate legislations. India doesn't, but many countries do have climate legislations or policies which can be enforced, or general environmental legislations which have climate-specific provisions, and therefore courts are then asked to intervene on requirement of enforcement of specific provisions. The third one, and this is very much, there are a few cases in Africa as well, but most cases are from Western Europe or Australia or in the United States, where keeping fossil fuels in the ground and not extracting them because we know they lead to greenhouse gas emissions. Corporate liability and responsibility is an important strategy that's being taken up by many parties, where they're realizing if they raise climate issues, it can hurt investment potential, and your kind of reputation in the market, as it were, gets hurt. So you can you can go down that route and require big corporations to claim responsibility or otherwise. The second last one is on adaptation, and incidentally, as I'll speak to it in the later part of my presentation, adaptation, one would think that in India, that's where the core of our problem lies, given that we are not a historically a high emitter of greenhouse gas, not historically high greenhouse gas emitter, but incidentally requiring to adapt to climate change impacts much more than many countries. We don't have litigation on adaptation right now, none significant as yet, but some countries are looking towards climate adaptation as well. And finally, about climate disclosure, which is requiring companies and government agencies to disclose what kind of greenhouse gas emissions they have. This is a long list of cases, but I'll not go through each of these, but maybe some of these we've heard of just in terms of the landmark cases of different courts outside of India, where various issues or aspects of climate change have been raised, and some have seen success and some have not in court. Some have seen success in court, but not in final implementation. So this is really a mixed bag. And I think one of the famous ones that I can think of is the Dutch Supreme Court in December 2019. And we all heard those who are working in this area, the Awadhendra case, where they basically said that the Netherlands was not ambitious enough in its plan for mitigation and that it needs to do much more. Many of these cases, the government comes back to say that this is a policy issue and therefore the courts cannot direct us to do something. But the courts, in some, for instance, in the Irish Supreme Court case has said that it's actually in the law. So if it's in the law or an act passed by Parliament, then we can, as the judiciary, come in and say that you have to meet the obligations in the statute. The last two actually are interesting. The second is the one in the Philippines, the Human Rights Commission of Philippines. They started this inquiry against a number of carbon emitter major corporations across the world. So this was not just Philippines, but multinational corporations. And they conducted an inquiry for, I think, 47 such major companies. And they came up with this report, which basically said that these corporations were aware of the impact of their actions. So in 2022 May report, they're saying that you cannot now say, oh, we didn't know that what we are going to do is going to lead or is going to contribute towards greenhouse gas emissions and therefore lead to climate change. And in that sense, the findings of this inquiry, which actually started several years ago, is significant, but what happens and where this report goes, one is yet to see. And the last one, again, this matter is pending, but this is I don't know how many you've heard of it. It's actually a Peruvian farmer who sued a company in Germany because basically due to ice melt, his farm and his village is getting inundated and flooded. And he has filed a case against an electricity generation company in Germany saying that your emissions over the years have in some way contributed to the greenhouse gas emissions in the atmosphere, which is leading to the glacial melt, which is leading to flooding. So, so these kind of are interesting questions of who's bringing these cases, where they are bringing the cases, and what are they trying to prove are kind of interesting issues. And just as I was saying, so standing again, I'll read these more in the context of the Indian cases, but standing. So who can bring the case? Can a farmer from Maharashtra bring a case in Washington, DC? I mean, it's a question of what his or her standing would be and how she would prove that in court. On what grounds would that court then review the decision or review the actions of the respondent? Then the third and perhaps the biggest piece of the pie is, how do you prove that that person or that company or that emitter contributed, and to what extent, to climate change? And the second part of that, which is equally important, is that climate change is responsible for the impact that the petitioner is feeling. Very often, and that's the science of attribution that a lot of scholars are now working on, it's been hard to prove that whatever the extreme weather events or whatever the natural calamities that are happening, are they happening because of climate change, or they're not happening due to climate change? And that's really ongoing research and science, and that's moving really fast. But imagine if it's moving fast and it's difficult to understand the group of scientists, to prove that in a group of non-scientists in a courtroom atmosphere is just doubly harder. And therefore, that's a real kind of sticky issue right now. And finally, if you're able to go through all of these, what is the remedy that you're seeking? Because the GHGs are already in the atmosphere. So are you seeking reparations? Are you seeking that the company shuts down? What should be the level of reparations and the restoration costs? So all those are also quite important questions. Right. So quickly to just say where we are in climate change in Indian law and policy. We don't have a climate legislation in India yet, nothing directly called climate law in India. There has been a recent amendment to the Energy Conservation Act, and we've had few other similar legislative moves which can be related to climate change. The energy and there have been at least 3 private member bills that have been introduced in Parliament, which haven't gone further, but they've just been introduced, which talk about bringing a law on climate change. One of the recent ones was, of course, on the net zero target that India has set up for itself. And that was a bill that was brought some months ago. Again, I believe in December, a new private member bill was introduced as well. But as of now, we don't have an act passed by Parliament. The Energy Conservation Act amendment introduces carbon credit system, which is a new thing. We don't know what the framework or the structure of that will be, but now there is a law that backs it. But I think Everything else that follows is yet to be put in motion. We, of course, have the National Action Plan on Climate Change with its several missions and what followed with each state coming up with its national action plans, state action plans. We now also have, some of you may have heard, Tamil Nadu has set up its own climate change cell. We've had some city level measures as well on climate change. There is, of course, an obvious shift towards renewables through incentives, subsidies. And finally, there are some government schemes which kind of focus on vulnerable communities. Which focus on vulnerable communities. So that's kind of the general overview of the law and policy on climate change in India as of now. Right. Now, even though we don't have these specific laws, there are several hooks in the Constitution and our statutory law for bringing cases to court on climate claims, or bringing climate claims to court, or climate-related claims to court. Indian judiciary and the way our Indian environmental jurisprudence has built over the years, we have a very strong foundation of rights-based claims, with several rights on environment, on human rights having been read in to Article 21, but also to Article 14, 19. Several of these rights have been read into various parts of the Chapter 3 of the Constitution. In the environment, and we have the whole public interest litigation docket that our judiciary is famous or infamous for, depending on which side of the spectrum you are. But it does give a lot of flexibility in the kind of cases that you can bring to court. In terms of the environmental issues, Articles 21, 47, 48A, 51, all these together have been considered by our courts to say that we have quite a solid foundation towards progressive environmental judgments that we can expect from our Indian courts. On the statutory part, interestingly, both the words environment and environment pollutant under the Environment Protection Act and air pollutant under the Air Act, they're very widely worded. So if we wanted to, we could very much interpret greenhouse gas as an environmental pollutant. The National Green Tribunal was about to do that in one case, but it hasn't gone down that route. But if we were to bring up, there is a very clear possibility interpreting GHG as an environmental pollutant. This, of course, has been a major point litigated in the United States, whether GHG is a regulated pollutant or not, but it's a possibility in India. We have other laws, of course, under Forest Conservation Act. So we have the Forest Conservation Act, we have the Indian Forest Act, we have laws for CAMPA, all of these which kind of are meant to disincentivize or regulate deforestation, which, as we know, forests are a carbon sink. Those can also be interpreted in some way to raise climate claims, or at least to look at some forms of, because India has submitted nationally determined contribution NDCs, and part of that is that we are going to increase our forest cover. So forest conservation laws could be brought in. Electricity laws, and as I mentioned, the Energy Conservation Act, they also provide hooks because we have obligations now on all the power sector companies on renewable energy certificates and such other things where companies have to generate some of the electricity from renewables. So there also we have some climate change relevant provisions. And finally, just these are not provisions in a statute, but the principles of precaution, intergenerational equity, public trust doctrine, all of these principles of environmental jurisprudence that are very much part of the Indian law now. We've learned from other jurisdictions and international law. All of these have been interpreted by courts outside of India to look at climate claims. And in India, since they're part of our environmental jurisprudence, one could think that it's possible that it would make it easier for our courts to now hear and decide on climate claims. And finally, our courts, as you know, love international law, but they have a love-hate relationship. So they use it in the way they like to use it, but sometimes it works. So there have been several judgments, particularly in the environmental sector, where the court referred to sustainable development goals, they've referred to Paris Agreement, they've referred to, starting from Stockholm Declaration, Rio Declaration, all the soft and hard laws, as it were, in international law, and said that India should follow all of them. So that helps in some ways. Sometimes it leads to unpredictable outcomes. But just to say that there is this kind of a landscape that we are working in, and this is the kind of landscape that our judiciary works in, which seems fairly fertile for climate change litigation to kind of come in and build. Okay, so now I have done this kind of categorization of what kind of climate claims have already come to India. The first of this is, and this is kind of the chunk of them, where the parties refer to climate impacts of a government decision or the inability of the government to regulate certain activities. Now, some of these cases, so the Sukhdev Vihar case is actually the waste to energy plant agitation that's been going on with the Sukhdev Vihar residents in Delhi for a long time, who didn't want the waste to energy plant to come up next to them, given the kind of emissions and poor environmental impact assessment that was done before a plant of that nature was permitted right next to a residential area. Now, interestingly, in that case, they said that this is going to lead to emissions and environmental impact, which is going to be adverse to all the people who live here. The National Green Tribunal permitted it, first of all. Therefore, the case was dismissed in that sense. But, and of course, the usual, we always assume that all the regulatory procedures will be followed and you'll meet all the standards and you'll comply with everything that you're supposed to comply with. But that apart, interestingly, the National Green Tribunal says that the waste to energy plant is considered to be a clean way to produce energy. And therefore, it's a CDM project, and CDM is a Clean Development Mechanism project. And therefore, in some way, it's gets a thumbs up from the climate angle. Right. So climate actually got used in a reverse way in that case to permit that project. The Rothang Pass case, I'll just come to say, the Rothang Pass case is one of those where the judiciary, and that time Justice Rothang Kumar was the chairperson of the National Green Tribunal, extensively talks about that region in the Himalayas and talks about how unstable it is, unique ecology needs to be protected, and talks in great detail about how black carbon, greenhouse gas emissions are leading to glacial melt, and the snow is melting, leading to all sorts of impacts. And at the end of it, it's about regulating tourism, which is what he was meant to do all the time, which is what the case was all about all the while, that we have to regulate tourism there because it has immense environmental impact. But the first part of the judgment is all about climate. But I think that's significant because it shows that it's entered the mind of our judiciary. It's in our climate conversation. The more, and once it's cited there, it will be cited sometime subsequently. Importantly, we don't have naysayers in our judiciary, at least none that I have come across as yet. We don't have any judge who, as of now, said, "Wait, climate change, we're not sure if it happens. We don't know. This is all bogey." None, at least that we don't have those, which we do have in other countries. We don't have that in India. They're all, and as this enters the conversation, we think more judges will be more sensitized to the issue. They'll start talking about this issue, asking the parties to present on the issue. The last case that's in that category, Society for Protection of Energy, Environment, Biodiversity, is actually challenging amendment to the EI notification, which made it easier or reduced the regulation for buildings and basically construction projects, which are a significant contributor to GHGs, the pie. And the MOEFCC in its wisdom went ahead and has diluted the scrutiny that these projects require before they get permission. And that was stayed by the National Green Tribunal, and in part they refer to the climate change impacts of these kind of activities. The second bunch of cases is where the court is being requested for better implementation of law. And this is where, for instance, the first case, Gaurav Bansal's case, where he said, look, we have the NAPCC, but no one's implementing it. So this was a direct, what I categorize as a core case, because the court was asked to implement the National Action Plan on Climate Change. The court said that, well, finally, the court didn't say, please implement the National Action Plan on Climate Change. But some of the interesting issues raised by MOEFCC was that it's a policy document. You can't direct us to implement a policy document because in law, it doesn't have the same weight that an act of parliament or the rules have. It's a policy document that the government has made up or prepared, and therefore you can't. But what the NGT interestingly does say is that once you do implement it, when you start specific implementation issues, you can bring to us. But again, I raise this as a case where NGT is again discussing climate change to quite an extent. And I'll just go into the last one here, which is the Indian Council on Environment League, the HFC 23 case. Now, HFC 23 is a known greenhouse gas case. It's a known greenhouse gas, and it's produced when a refrigerant is produced in through the process. It's as of now not regulated properly in India. So the issue before the court was whether it can direct the MOEFCC to regulate a GHG. That's the case where, as I said earlier, the court, NGT very clearly said that it is a GHG, which we know causes climate change, and therefore, in our understanding, it's an environmental pollutant. But again, the NGT at the end dithers and says that these are issues that are being taken up on the international stage because we have the Montreal Protocol and the other ozone-related discussions. And this is something we are sure that the government of India will take into consideration and regulate adequately. So we can go. Sorry, can you just go back? There's just one case, only because some people, it's made it to the headlines, was the Ridhima Pandey case. You may have heard of her, some of you. So Ridhima Pandey was a minor who, she in fact then went, you know, the whole Greta Thunberg group, she's part of that now. She raised a very direct issue of how our environment clearance processes and our forest clearance processes don't take into account climate change. And, you know, referred her, I've looked at her, the case that she raises, you know, refers extensively to climate change, evidence of climate change, refers extensively to international documents. Unfortunately, the NGT disposes of this case by saying, yes, important problem, but we assume that the government of India will take into considerations all these issues when it approves a project. So full faith in the government of India to ensure all its environmental regulatory processes are in line with climate change concerns. Next, yeah. So this is, again, these are where the parties have requested that new policies or the realignment of existing policies in light of climate concerns. So this, again, this is a case before the National Green Tribunal. It's a wind farm, massive wind farm coming up in Andhra Pradesh, I believe. And the case that the petitioners raised was that, look, this wind farm has been permitted because our government permits these renewable energy sources, are given a lot of leniency in terms of regulatory requirements. But they said that this wind farm actually has massive environmental impacts. And please make sure that the law requires wind farms also to go through the same environmental impact regulatory process. The court said, it's a wind farm, it's a clean energy, therefore no. So again, climate change being used in two different ways. And the final one, the Wilfred case, is actually about a deep water sea port coming up along the coast of Kerala. The whole, that area is extremely unique, extremely, what do I say? The ecology is very, not weak, but fragile, exactly, fragile. And also it's the coast, and therefore most the potential of it getting inundated due to the rising sea level is very high. But yet we are spending crores and crores of rupees to come up with a massive infrastructure project there, but it has been permitted in national interest. Moving on, the last bunch of cases is where the government actually uses climate concerns to defend its own decision, which is unusual, but it has done this where it has, it was a case where the petitioner said that this cess on timber, you have raised it without any reason, cess being a form of tax or a fee. But the government said, no, that's because you're saving our trees. Quite apart from the fact that the government is not saving its trees anywhere else, but it has used this argument in this. So that's kind of the categorization. I have not gone through the whole bunch of cases in detail, but that's what has not happened in India as yet, which we are seeing a lot in the United States cases, is that where companies go to court challenging the government's policy on climate, where the government has tried to tighten some regulatory standard or emission standard and say you have to meet this standard because of climate concerns. And the companies have gone to say that either you cannot do this or this is unfair or whatever, you don't have the legal this thing. That as yet has not happened in India, perhaps because the government has not been so proactive on the other side. But that could also happen going forward. Next slide. So just going to what the potential and prospects of this kind of climate change litigation in India are. I think they're likely to grow. We're going to have more and more judges and parties raising these kind of issues, referring to more and more science that's coming in. But in my understanding, it's going to remain in the periphery. It's going to be one of the issues that are going to come out when you say you want to challenge a clearance given to a power plant. So you will raise many issues, but you may also raise the issue that the impact of greenhouse gas emissions from burning coal is going to be one of them. So I think it's going to increase. And as I said before, there's fertile ground given the way our judiciary has moved, given our rights-based jurisdiction, PILs, the National Green Tribunal has a pretty wide ambit. So there is it's likely to grow. Also, we are a highly vulnerable country. As I said, we haven't seen any adaptation claim yet, but why not? I mean, we are seeing so many cities and other regions getting affected by extreme weather events. Sooner or later, this will come to court where people and groups and organizations will start claiming. And I also believe if more and more there are policies at state level or the municipal level, or now at all of these new policies, plans, laws, rules will start giving more and more hooks for these claims to come up. Emissions are increasing rapidly across the country. And therefore mitigation claims consequently are also going to rise in courts. Also, I must say the quality of expert evidence that's available is also increasing than it was before. Not only that, people are now, lawyers are talking to people outside. They are reaching out to scientists and social scientists and people who actually understand what's happening on ground, asking for these reports so they can put it before the courts. So those conversations across disciplines are increasing, which can only hopefully mean positive things. The core benefit approach is actually there in our National Action Plan. And I think that's actually the approach that's going to take the lead, where, for instance, in cases of air quality, which we need many of those, where local environmental issues on air quality, waste disposal, construction, all of these will raise climate impacts or climate benefits as a co-benefit from if we regulate air quality better. And as I said, the prospects look good. We do have an activist, and I say that in quotes because it means many things. Let's say the judiciary has on occasion given progressive judgments. On occasion. We also have the National Green Tribunal, which has expertise, more expertise than a conventional bench. We do have relaxed rules of standing. For instance, in the United States, one of the most celebrated cases, the Juliana case, actually got stuck, not just for standing, but also because what is the nature of evidence and what is the nature of remedy that you're seeking. All of those rules of procedure are not as strict in India as they are in other jurisdictions. So conventional problems, as it were, of climate litigation may not be as relevant in India as they are in other jurisdictions. Indian judiciary's engagement with international law, as I said, it's quite extensive. And that could be a very positive thing as far as climate change is concerned. And in fact, several judgments, particularly those authored by the current Chief Justice, refer to the environmental rule of law, and he talks about the SDGs quite extensively. And he talks SDGs, Paris Agreement, our country, the kind of extreme weather events and changes that we are facing. Several of Justice Chandrachud's judgments refer to that in his environmental cases. Again, I'm not talking about the outcome, I'm talking about the discussion in his judgment. And of course, as I said, more and more robust evidence is emerging. Having said that, I think I must also give just the tone of caution. And I say that for at least 3 reasons. And I think the first one is something we are all very well aware of. Our courts have a massive backlog of cases. They have an overflowing docket, and that docket is not just true for and is equally true for environmental cases. So if we now file a case, let us not be awfully optimistic that it's going to get resolved in the near future. So that problem of our Indian judiciary and its functioning afflicts environmental issues as much as any other issue. The second is, while the judiciary has given progressive judgments, our judiciary on balance has been reluctant to enter the policy arena. And many of these issues on climate change are very clearly economic, defense, national interest related, developmental agenda. We need to have enough, you can always raise the issue that so much population does not have access to power, does not have access to electricity, gas. All of that can be very validly raised. And in that case, our courts are known to take a step back. They are known to take a step back on massive infrastructure projects. There's enough evidence and writing showing that many of these big, for instance, hydropower cases, thermal power cases, the court has taken a different view. And finally, all of this analysis I'm doing based on what the judgments I have read. What happens in court is often not reflected in the judgments. So it is quite possible that there was an extensive argument on climate change that I or any other scholar outside has no idea about, because our pleadings are not available to the public. Our pleadings are, unless you know the lawyer and the, whatever. And we also are not very sure, or that's just the way our judiciary and their judgment writing is. It's not very.
Thank you very much. That was a very rapid,
Sorry.
both done in good time, 40, 45 minutes, both through potentially what can be done and what is happening, and also some of the limits that we know from other cases also, which plague the Indian judiciary. I had a couple of observations, and then we can just open the floor to questions. It's up to you. Do you want to take them one at a time or together? The most general is how do we read judgments? And the thing that comes through your presentation here, from those of us who work on issues of law but are not trained in law, it clearly, the judgments in India are wonderful because they talk about so many things other than the actual operational part of it. And some people actually have made a case that what matters don't get the remedy, it matters. But as a person who's interested in that issue, there's so much more that comes up in the course of, and so there's something quite interesting about how to approach this. And similarly, the last issue that you brought up about something that Anuj had done in his book on the need to do an ethnography of the court. It's not just the judgments, but also what happens in that space. So at a general level, how do we engage with law outside its own text, as it were, which it refers to a particular issue? Two questions on this co-benefits and this waste to energy thing. In the co-benefit case, from what I understand, both the waste to energy plant and this wind farm thing actually is going the other way. So you're not getting co-benefits. You're actually using one to counter the other. And there is some interesting literature that's come out on the environmental impacts of renewables. And this is something that we take for granted, that renewables mean something good. But there is good ethnography. There's one very good work on Mexico that I've read on what can happen if you design your renewable energy programs in certain ways. For instance, if you do a large scale thing rather than a decentralized thing, does it become just any other industry then in terms of its impact? So again, I would like to think through the scope benefits, think like, does it really happen in that way, or is it being used one against the other? On Article 21, since so much of the air pollution is through that Article 21, my own reading, it is, correct me if I'm wrong, that much of it takes as its basis some improvement in human health. Sometimes it goes beyond human health to also talk about one health occasionally, but it's mostly that we deserve clean air and clean water. And because that's, as human beings, it's our right to have access to these things. In climate, what would that argument be? Is it going to be about jobs? Is it going to be about loss of or inundation, so loss of the possibility of living in a place? I'm not, because in this one, I think the health argument provides an anchoring for the talk about, clean air and clean water, etc. My final thing on NGT, would you, okay, there's a proposition that there are two phases in the NGT. There's NGT 1, and there is the current NGT, which seems much more anxious to have the balance and to permit things provided safeguards are being met. And how does one read the change of phase? Because I just happened to read through a PhD thesis that I was asked to examine. And one of the points that the scholar is making is not only about the changing composition in terms of the changing outlook, but also the changing composition. So the experts that you mentioned, increasingly from the evidence that I found in that thesis, don't seem to be technical experts. These are more and more administrative experts, or at best drawn from the pollution control boards. So the independent technical experts that they had seem to be on the way out. So what does that say about the future of environmental law more generally, but certainly in climate case, if you're going to rely more and more on people who are part of the system already? So it's up to you. Yeah.
Yeah, sure. Well, no, those are really, really good questions. How do we read judgments? I mean, that's really, really a difficult one. No, I completely agree with you that, and I think we do that as some of us who are legal researchers as well, or even if you're not lawyers, but people who research areas of law. I think there is value in the judgment, even if it's not the final, what the actual outcome is. I think there is value to it. But there is no, I mean, yes, technically there is no value to it in terms of you can't ask that to be enforced, because that's not the direction of the court, but it's something that the court thought about. But what we've noticed over the years is that these are the bits that then get quoted subsequently in other cases or other pleadings. And slowly, that then becomes part of some directions. So I think there is value to it in kind of a soft way, because there's no way of enforcing it, but just to understand the thinking of the court and what kind of arguments happened in court. So, but at the same time, I do also feel, when I wear my lawyer hat, that academics and scholars actually put too much weight on that also sometimes. So I feel that, so for instance, you see in the media that the court said this, and then you'll get people asking, and many of us say, like, unless it is written in the final order, judges can say whatever they like in the banter that's happening in court, short of putting anyone in jail. I mean, they will have this banter, and it's really the part of the adversarial system that we have. Unless it's something they put in writing, we really cannot put too much weight on it. That's because, and I know that's slightly different from what you were saying, but I just wanted to highlight that, because I often see that, particularly in socioeconomic rights and environmental ongoing cases, that you'd have these headlines that the judge said this, but then you go and read the order, the judge actually doesn't put it down, because he's at some level, some of them are grandstanding, they just want to say this, but when there'll be more arguments, or when the judge considers this further, then decides that maybe balance, as you said, has maintained. So yes, I think one has to be, all that I can say is one just has to be cautious. I don't know. I don't think there is a way to, there's no, a guidebook to tell us how to do it. On the question of, and I completely agree with you about ethnography of courts, and Anuj's work and many others who are working about particular cases and seeing what all go into that. It really does reveal how much goes into a final judgment, and how much goes into that final judgment, and how much will go into what happens to that after the final judgment is actually delivered. When we had this whole smog towers cases, and so many people wrote about it and said, lack of evidence, kyun kar rahe hain, kya hai, who asked you to do it? But still, it's part of the order, and people are spending the PCBs, and the government is allocating crores of rupees every year to set up these smog towers and to set up evidence to see if these smog towers work. All of that is happening in this context where so many people actually had said it's not going to work. I mean, there's not enough evidence. But what we still don't know, why did the Supreme Court switch on this thing in it? What switched the Supreme Court? Nahi, bhai, ab to we'll do smog towers, that will solve our problem. So it's like, I think ethnography of courts might tell us some of what goes into some of these kind of orders. On the Article 21, what kind of rights? You're right. I mean, there's not a specific, you can't say I have a right to not let the climate change. I mean, how would you articulate that right is perhaps what you, I think my answer would be what impacts are going to follow from climate change, or to reduce the cause of climate change. So it could be worded, for instance, that I have a right to not right to housing, and therefore my house cannot be at a low line. And if my house is at a low lying area, the government should take enough, ensure that that area adapts to possible rise in sea level. Or that I have a right to food, and the fact that increasing heat is changing agrarian practices is something that we need to consider. Or that I have a right to livelihood. Or I think it will be very much along human rights that we've already established, and then making that change to impacts from climate change, which I think would not be difficult, because climate change really will be impacting every sector of our economy, which it already is. I also on that issue of co-benefits, absolutely. I think you are right that the impacts of renewable energy projects has not been considered carefully. And many of us have written on it because, for instance, the draft EI notification that was issued said that all renewable energy projects will not be requiring an EI, not be requiring an environmental clearance. Now, that's really know the scale of that project. You don't know where it's coming up. A lot of research is saying it's coming up in what they are calling is barren land or wasteland. But you're actually covering, for instance, common lands which were being used by people for other, for their cattle or things like that. I mean, there's huge impacts not only ecologically but socially, economically. So yes, I completely agree with you that these renewable energy and the co-benefits of these renewable energy plants have to be. But I think I use the co-benefits approach in a more specific way to say that our local environmental problems are going to remain the center stage of our cases in courts. And there, if there is some co-benefit argument on climate change, yes, that's the way I was looking at co-benefits really. On the final issue of National Green Tribunal, I mean, I wouldn't go into phase 1 and phase 2, but definitely what was envisaged in the law as passed by Parliament is not what is being followed in spirit. The idea of having experts sitting with judicial members was that they would have solid expertise in a variety of areas. And that while some of them may be IS officers and IFS officers, but there would be people from the private sector, people who would, nothing stops them from being civil society organizations, social scientists. I mean, people who have all of the environmental cases that come to the NGT require these kind of expertise. And you're right, and a lot of people have made these observations that the expertise currently available to the NGT is fairly lopsided. And not only is lopsided, if you look at the functioning of the NGT, is there any point in giving a case on, say, forest clearance, forest diversion to a person who may have expertise in solid waste management? So, I mean, at least, so that's a second level problem, that you may have expertise on the bench, but is that expert listening to the case in hand? But there's no point in a hydropower project being heard by a person who has no expertise in that area. So the case management or allocation is also not happening based on the expertise, whatever is available. So there's actually the problem is perhaps worse than what you stated it to be. But all that I was trying to make is that it's a law, it provides for expertise, and it's already passed by, it's in our law book. So therefore, perhaps we could be a little optimistic about it. Right.
Yes. So those who are on Zoom, if you want to write in into the Q&A box or raising hand is something that you can see if people raise hands. Either way, yeah, in the meanwhile, we'll take some questions from here. Praveen?
Yeah, hi.
Hi.
It's a naive question, sorry. So change in climate change is most of the time it has a negative connotation, right? The question of erosion, something is going bad. So do you think that in litigation, there is another way to look at it, look at the question of climate and climate change, except the question of change?
So you think whether the courts are considering the positive impact of climate change?
We need to take care of that, for example.
Right. So I mean, wouldn't so for instance, if we are considering issues of upcoming power plants, which are not set up, they are set up, would contribute to greenhouse gas emissions. So would you consider, so that could be something which happens before a cause to climate change comes online. So in that sense, preempting certain causes from yes. So yes, of course. I mean, if again, these are some of these cases have come up with also the potential of litigation. If we were to stop, for instance, forest clearance and therefore remove that carbon, since if we could come to court in time before those forests are cleared, in that sense, we can protect the carbon. And in that sense, the court could play a proactive role before the damage, if that are in part.
Why I ask this is because in context of climate change and its scale and the complex entanglements of, oceanic currents or wind streams and so on and so forth, or moving pollutants, why is it the assumption that court cases can only be lodged and heard with boundaries? Or that the nature of attribution will have to follow the which has no mediating moments. It's a direct attribution. In activist circles in India, but also globally, where the terms of law are being demanded that they should, the terms of law, the terms of national jurisprudence or national jurisdiction should be now rethought in a context such as that of climate change.
Right. No, I think you're absolutely need to be rethought in that sense. And there are already examples, for instance, the Peruvian farmer filing the case in Germany. Now, there's no problem. It really now depends on every jurisdiction. So some countries are, their laws will permit the Peruvian farmer to file the case. And in some countries, so it's question. So there are two questions. Actually, there's a question of standing in terms of who can bring the case to court. So that's actually a slightly different question, because in India, for instance, do you have to prove that I am the Peruvian farmer whose farm was inundated, right? Or can it be an NGO sitting in the capital who is fighting rights of people? So for instance, in Netherlands, the Awadhendra case, they allowed the organization that represented everyone. So they allowed the standing of an organization, but they didn't allow 780 people as individuals to go. So that question of standing is, were you affected directly, or that NGO will represent? that's a separate question, which is also an important question. Because, for instance, while in India, particularly like the National Green Tribunal and also Supreme Court, High Court are usually very relaxed about this. As long as you have a bona fide case, you could be sitting anywhere in the country and challenge the environmental impact of a project. So National Green Tribunal said that you have, as a citizen of the country, as long as it's prima facie, there's a case. You're not doing it because you don't like the guy who came up with the project. We will take it even if it's so we have that's why I said the low standing issue in India is very wide. But I think the second part of your question, which is I think extremely crucial in climate, is because the source is somewhere, the impact is somewhere else, right? And I think that is being challenged. That issue is now being, for instance, the Philippines, the 47 major contributors are based across the world. So they are not restricting themselves to Philippines. Or, for instance, the European Court of Human Rights, all these bigger international bodies, they are not restricting themselves, but some of them have procedural, inbuilt procedural checks. So that way, some jurisdictions are slightly more flexible, and some are not. And I think that's changing. And for climate, I think they are realizing that it's not the run of the mill. Okay, that's a bad metaphor. It's not the usual. It's not the usual discharge of effluent leading to this. So therefore, you can, yeah. Why?
I had a similar question from a different vantage point. So it's about causation and attribution. Why does that become, I get that it's a law of evidence, but why does it become so necessary when, like you're saying, locus standi has disappeared in the 80s? The court can take its own motto in a way, and we live in the age of judicial populism, right? And our principles itself are like precautionary principle is so ambiguous, even fading. So why does causation need to be strict while all the principles and the medium itself is so ambiguous and free flowing? Secondly, the NGT has a large scope, right? But I just want to put this problematic of is its scope a bit too large? Like I've read a few judgments where they are just doing the work of rail inspectors. It's a one-page orders without orbiters, one-page orders. So like, is its scope too wide?
Oh, that's a. So the first question, actually, I think maybe it's my fault. So the issue of causation and attribution, what I was actually trying to say that issue may not be as big an issue for us because we are so flexible on principles and rights. So you're right to, as you said, when we are able to use so many principles and, kind of reading in rights, and we are often open to these liberal interpretations. So that is exactly why my prediction is that on causation and attribution also, we will not be that strict when we come to that. It is stricter in jurisdictions where everything else is also strict. So in the United States, they will be very strict to say, why are you filing it against this electric power generator? How can you prove that the GHG produced from there impacted your field, which is a very difficult thing that link is very difficult. So they call it, several, and attribution science that way is, improving drastically. I mean, they're able to prove a lot of things more, and I'm glad it's coming into it. And there's actually now writing also that shows how attribution science is coming into cases. But the question, so they call it like a drop in the ocean. So, this is just, or a death by 1,000 cuts. So, I mean, there are several metaphors that are used to show that why am I only being held responsible when, there's so many other. So that kind of an causation problem in Indian courts may not happen because we also have this contributory negligence. As long as you can prove you were part of the problem, you will be held responsible for that part of the problem. Just because there were 5 other people held responsible doesn't mean that you will not be held responsible. The issue on NGT's jurisdiction and what it does with the jurisdiction that it exercises is kind of an open question. I mean, in some ways I couldn't agree with you more, but in some ways I couldn't. It's just that often what the National Green Tribunal, we see them doing is that they'll set up a committee, which they are not part of. They'll set up a committee which has pollution control board members, some IIT members, some, some school of mining members, some, so-called expert members. And they will say, you go do an inspection, the inspection report will come back. They will just copy the report and accept the recommendations. But that's not what you were set up for. You have been given extensive power to actually then go into the nitty-gritties of those recommendations and discuss them, open them to the parties, discuss them. So I think to that extent, the NGT, while it gives these recommendations, I don't think it's engaging with the committee recommendations. It's in some senses, and I'm not the one saying this, but the Supreme Court has said that it's just outsourcing its work, delegating its work without any proper supervision. And that's not what the NGT is. And NGT has the power of what we call the merit review. So they are supposed to look into every issue of merit. That they do. But I don't think that's an issue of their jurisdiction being violated. I think it's an issue of them not using their powers adequately. Yeah.
One more. You're making a distinction between climate jurisprudence and environmental jurisprudence, right? Like we do have the Air Act, the Water Act, and we know Air Act is the copy of the Water Act. More or less. So I'm saying, isn't this vagueness of these acts itself environmental climate jurisprudence?
Sorry, the vagueness of the act?
These acts itself form as a climate jurisprudence. I know you are making a distinction between environment and climate jurisprudence, the words, but don't these acts, like these are such vague acts, copies of each other. So don't they in a way become open to interpretation in a way and become climate jurisprudence?
Well, yeah, that's what I'm trying to say is that because they can be interpreted, that we can bring in climate legal provisions on climate without actually having that climate law. So I think that vagueness that you're calling vagueness, I agree in some ways doesn't help us in environmental regulation, but as far as climate regulation is concerned, can be useful because greenhouse gases can be interpreted. But I also just want to make a point here that I'm not of the view that climate is perhaps some ways bigger in some ways. I think all these environmental legislations, environmental regulatory agencies, I mean, tomorrow, we don't know pollution control boards, which in any case are understaffed, under-resourced, poorly managed. We don't know from next, they might be required to start regulating GHGs. And that's a problem because when I say air pollutant can be a GHG, are we tomorrow going to ask a state pollution control board, which can barely do the job that it's required to do right now, to start accounting for greenhouse gas emissions and ensuring its mitigation? So that's kind of answering your question in a very roundabout way, but I wasn't making the point that the vagueness, I think the vagueness, in fact, is going to can lead to climate regulation till we actually have a climate law.
I think I just want to add a little bit to this, which is about, is the informalization leading to not following the rule of precedence in interpreting environmental doctrines?
Yeah. So yes, I think in part it does lead to, yeah. Yeah, so you're right. I mean, the informality or the the flexibility sometimes does lead to the problem that precedent is ignored. I agree with you, but I think it does have benefits. I mean, if you go back to the original idea of having an environmental tribunal or having the PIL, was to make these institutions more accessible. And in some ways they have. I mean, I am a critique of, I appear before the NGT, but the truth is, in front of the NGT, at least my matter will come up in 1 or 2 months. At least someone will hear my matter. In the High Court or Supreme Court, that same matter will not come up for 2 years. I mean, so in some senses, one can think about accessibility in that way. Many counterpoints. What is the point of having NGT in 5 cities of this country? I would rather say go to the High Court in the capital city of the country. That's more accessible. Often people know legal counsel in the same state. You may not know the legal counsels in Pune or Chennai or Bhopal or wherever it is. But for environmental cases, in some ways, at least, there is this special forum which is creating its own jurisprudence. I'm saying in the law books, there's a lot of potential for it to do. It has some of its progressive judgments, like on locus standi and all, have been very useful. But yeah, I mean, often, as we see in any institution, legal or otherwise, people at the helm of affairs will make the difference. So I mean, that the law cannot change that. The law will, the institutional makeup, the institutional culture will always affect the working of the act. But yeah, just to the short point that yes, ignoring precedent, we do it at our own risk. But sometimes the way some of our judgments are written, perhaps best to ignore some of them as precedent also, on the other hand.
You want to go ahead? Okay.
interesting discussion and a lot of the overview that you did, which I thought was really rich and helpful. So I guess question that I had was just about the stakes of putting something into a legal argument that's about climate and what that actually does or doesn't do. So I guess the question is, I mean, you had identified 3 cases and then sort of 15 to 17 peripheral ones, but then you're also talking about how cases that are helping the poor, affecting rights to housing, are talking about things that are happening on the coastal line. Those are all, I guess, very important ways of remedying problems for the poor. And I guess the question is sort of what is the advantage of putting it as a climate argument or an environmental argument as opposed to having the discussion about poverty or inequality? So, why kind of adopt this large globalist framing when some local framings that kind of tie into people's problems might be more effective? And I mean, it does remind me to like longstanding environmental criticisms made back to Agarwal and Narayan about how emissions were different for the poor versus for the wealthy. So, I mean, the global discourse of climate is one thing, and it's one that comes from science, but, maybe it's not looking at the right sets of things. So I'm just wondering how you sort of position this into these other questions of power and politics that we might be interested in.
No, thank you. That's a fantastic question, actually. So one thing is, I should have clarified. So I'm just laying this out as someone who's analyzed what's happening. So I'm not necessarily propagating that climate claims should be in our cases. So to answer your question that, okay, so that's my personal view, but I guess your question is larger, whether it helps to give it a climate angle when there is a very strong non-climate, poverty, human rights, development angle. I think, first of all, I tell you, it's as lawyers and as Indian lawyers, as I know, we take whatever we get. So you look at any appeal or petition we file, we'll put in as many arguments as we can possibly find, because we don't know what will grab the eyes or attention of the judiciary. And I'm saying that perhaps a little flippantly, but that is true. Because a lot of these human rights cases, a lot of these PIL cases, the odds are really stacked against the people, the vulnerable communities, or the groups who are claiming those rights because of, systemic problems. The government is against them. They have a really tough uphill battle once they've come to court. As it is, coming to court is hard. So once they've come to court, they're going to try every single tool that they can find to fight that, right? And so if that means trying to get in through the side door, back door, any international obligation or any evidence, they will use it. The flip side of that is many of our judges, for whatever reason, actually find these foreign law, international law arguments attractive. And it's interesting, I mean, my former colleague, Professor Lavanya Rajamani, has done this analysis, among others, that if you closely look at the use of the international law obligation, we actually don't have that obligation, but our courts have interpreted that to mean that in some way we've had that obligation, and they have then given their judgment. And that judgment may have been favorable for the environment or the socioeconomic writing. So, I don't know if I could answer your question, but I think at the end comes down to a strategic issue, whether it helps.
I think at a time when courts seem to privilege environment, maybe in time climate arguments over even simple economic rights arguments, it makes sense to go to the court and use that language. Why not? Yeah, I mean, if we went to the courts for a slum demolition case in Delhi, and we approached a very eminent lawyer, but the way he had framed it was entirely in social economic terms. And I was like, why can't you talk energy? Why can't you talk the language the courts want to hear, rather than stick to tried and tested arguments the courts are throwing out? So sometimes it is a pragmatic question. Sometimes it's helpful. Other times, I don't know how helpful it is. On that note, I think we've had a very good session. And thank you so much for coming by in a rush,
No,
straight to the court. I had just one concluding, sorry, you want to ask a question? Okay, go ahead. And then I had a concluding statement. Yeah. Just wait for a minute. Yeah. Huh.
Next is related to Andaman Island. The Supreme Court of India appointed a committee, Shekhar Singh Committee, uh, which is related to tribal policies in Andaman and Nicobar Island, which recommended, and even court said that government policies, government of India policies related to the development of island directly degrading the ecology of the island, such as Andaman Trunk Road, and that more likely promoting the timber extraction from the island, etc. The Supreme Court decision in 2003 was to shut down that road, but still it is functioning. And yet, because the administration is saying that they are not in the position to implement the decision, and recently the government of India used one of its island as a strategic security location and tourist hub for India. For that, they implemented 4 mega projects in the island, and that will directly cut 8 lakh trees of the fragile ecological island. And for the compensation for that, they planting trees at Haryana. And
Yeah, so the impacts also happen elsewhere and the compensation also happens elsewhere. So is there any specific question that you want to put?
yes. In this context, where court orders were not implemented by the administration on the ground, and government is also involved as an actor in the exploitation of environment in the name of development. Where we can go through about these, where we could find any kind of solution related to these.
I don't know. I mean, we face this all the time. I mean, and I don't think that's a problem really only for environmental cases, poor implementation. If we get a favorable order from the court, which in itself is a big IF, then implementing that order is really hard, and ensuring the implementation in letter and spirit even hard. So, I mean, it's true. Many of us are like, why are you coming to the court? You will get stuck. But we also are cognizant of the fact that many of these people, organizations who are fighting, have been running up against government agencies and authorities for years together and not found a sympathetic. And therefore, they only see the court as their final kind of savior. And then sometimes the court comes through and many times it doesn't. But it is a very frustrating thing. I mean, I don't know how else to comment. And it's true, the government looks at environment very often as an asset, natural resource asset at its disposal. It doesn't see it as something that it holds in public trust, that it needs to ensure in perpetuity for all these principles of intergenerational equity and public trust doctrine. And, all these things are very much part of our environmental jurisprudence, but not so much part of our day-to-day governance, unfortunately. Sorry, I don't have a more optimistic response.
On several issues. The implementation
Yes.
question is something we can discuss. I just wanted to conclude by thanking Shibani for bringing a lot of complicated and difficult issues in a language, as you said, was going to be non-technical, and you said, which it was. So thank you very much for that. Also, this now I've just been reading a book which begins with a bunch of climate activists and climate scientists sitting in a room in Manchester, and it starts to rain. And the author, Emma Knox, she begins by saying, for most people, it's rain. But for people in this room, there's some relationship that they kind of see between this rain and climate change. And so in some senses, climate is something that we have to learn to think with several other issues rather than as a discrete thing in itself, which must be addressed discreetly. And one thing that we're trying to do is to build that conversation. What else can we think climate? And hopefully, as we get more people to come and address us, we will have a better sense of how to think with climate. So thank you very much. And thank you, Shibani.
Thank you.